Gotta be like Mike. What would Law Daddy do? Hello, everyone. Welcome to Court with Krissy. Here are 4 short court clips you probably didn't catch. Stick around for every second. It's worth it. I hope you like it. Court with Krissy's now in session.
Oh, I get it now. Okay. Ms. Kuchera, I don't have your attorney. He should be calling in or something. Kuchera, what is it? Kuchera? Kuchera? Kuchera. Okay. Don't need to go there. Go here. One 651 9.
Please try again. The number you have entered has not been recognized.
How I not? Six, 5, 1, 7, 8, 9, 6, 5, 4, 5, 6.
Please try again.
You try it without the 1.
Try it without the 1. I think I've always had to do 1, but we'll see. Maybe it's a 612 number.
You have entered has not been recognized.
I'm gonna try looking him up. That's what I'm gonna try to do. He's disbarred. Oh,
Not yet.
well,
Not in Wisconsin. There's
Okay.
a pending case.
oh, well,
He's only disbarred in
just
Minnesota.
in Minnesota. Just in Minnesota. Alrighty then. Prominent Twin Cities Michael Padden disbarred. Prominent Twin Cities attorney Michael Padden disbarred. Well, his number is not recognized, so
Maybe he thinks he's disbarred in Wisconsin, because I know that Minnesota filed a complaint against him in Wisconsin on
I'm gonna
October
probably
17th.
say you need a new attorney. Probably what I'm gonna say. Probably. Do you pay him? I'd probably get your money back. Probably do that. Or ask for it, but sorry. Yeah, because that's the new news is prominent Twin Cities attorney Michael Padden disbarred, not just suspended, disbarred, cut, throw, gone. Okay. So I'm going to give you some time to find somebody else. All right.
For what it's worth, he never filed a discovery demand and we haven't provided any.
I don't know how much you've paid him. You don't have to tell me, but I would try and get that back. Just friendly advice. All right, so. Did it take you a lot of time to save what you needed to get to him? Oh, wait, okay, Miss Kuchera, Kuchera, I'm gonna get it, I promise. Miss Kuchera, why don't you come have a seat up here? Because I'm gonna guess you don't want him anymore and he can't even probably practice anymore, so can we just remove him?
Yes.
And then we can just talk?
Yeah.
All right. We will go on the record in the matter 24 CM 213, State of Wisconsin versus Krissy Kuchera. The state appears through District Attorney Kevin Schmidt in person. Ms. Kuchera appears in person without counsel Michael Padden. The court attempted to call Michael Padden's number 3 times. All times it came back that this number is no longer, doesn't exist. The court searched for Michael Padden's contact information. When the court did a search for Michael Padden to get additional contact information to call Mr. Padden to notify him of his tardiness for today's hearing, big headline from January 4th came up saying prominent Twin Cities attorney Michael Padden disbarred. So that just leaves me to believe that perhaps he's not able to represent Ms. Kuchera, and Ms. Kuchera has personally paid for his services. So Ms. Kuchera, you have a few things that you need to take care of. I'm going to guess that even hearing that news, even if by some chance, some grace of God, he may still have his license here in Wisconsin, hearing that he's disbarred in Minnesota probably gives you a little bit of angst.
And I had just contacted him Monday to remind him that we had court and he never mentioned it.
Oh, well, it's kind of interesting. Did you contact him on the number I just contacted him at?
I can give you the number.
I would love it if you could, because I just called this number and it says it doesn't work.
Yeah, 612.
Okay, well, that's not the number that I have. And that's not the number that came up. I don't know. And here's the thing. It's up to you and whatever you want to do. If you want him to continue as your attorney, that's your right. If you don't, that's your right too. Completely whatever you want to do. I called the case because you have $1,000 posted because you failed to come to court. So there's $1,000 posted. And what I was going to do was going to see if you wanted him to continue. If you didn't, I was going to remove him, and I was going to see if there was an offer, and I was going to see if there was any restitution. But I'm just going to ask if there is any restitution because I don't have any disposition supplement. No, there's no restitution here. And so I'm not even sure where this case is going. I don't even know what's going to happen. Off the record, your attorney stated that there, and I'm noticing in my electronic file, no demand for discovery has been done yet.
Yeah, I thought that was kind of odd myself.
Therefore, it's kind of at a still, nothing's happening. So I don't know what you want to do. We can't talk about the case or where it's going or even an offer if you're keeping Mr. Padden as your counsel. He fails to appear. You said you talked to him on Monday, reminded him. You, the client, reminded the attorney. You, the client, reminded the attorney that there was a hearing. That usually goes the other way around. Like usually the attorney has the job of reminding the client, but good for you for being responsible and reminding your attorney who has failed to appear. All right. And again, it's not the court's job to even contact him to appear. He should be appearing, especially when the court gave him permission to appear by video, and he's not appearing by any means. I have Zoom up and there is no appearance. Okay. So I'm not going to put you on the spot. I'd like to know if there's an offer, but I'm just going to kind of do a quick little turnaround to give you time to think about what you want to do. Maybe talk to attorney or ex-attorney Padden and figure it out. Mr. Schmidt.
Offer would be a ticket for 346,675 sub 1. That's owner's liability for failure to stop after accident, which is according to the bail schedule book, $767.50.
$767.50. And what was the statute?
346.675 sub 1. The owner liability version of it is a ticket, not a crime.
All right. So you can think about it even more. And again, I don't even know what's going through your head right now. Okay. I don't know what's going through your head. You probably have a lot. But
honestly, I'm okay with just going ahead and proceeding without Mr. Padden.
And you want to make the intelligent, knowing, and voluntary choice to remove him as your attorney right now? All right. So therefore, the court will strike him and will withdraw him from the record as your counsel. And so you can understand, and now I'm going to see if you understand the offer that's been presented. All right. You have been charged with the crime, hit and run, as a misdemeanor. This hit and run misdemeanor crime has a maximum possible penalty of up to $1,000 fine and up to 6 months of jail. Okay. Mr. Schmidt has made an offer to you to amend it to a ticket. All right. To a ticket for $767.50 under owner's liability for failure to notify of an accident. Okay. You have $1,000 posted. That would cover a ticket if that's what you wish to do. I can give you time to think about this and have you come back in the next week or so. We can take care of it here today. Whatever you want to do. I don't want to put you on the spot. This is a lot for you to think about.
I'm okay with just taking the ticket and just going ahead and getting this over with.
You want to accept the responsibility, be accountable for your actions, and take a ticket for the fine.
Yes.
All right. Mr. Schmidt, formal motion to amend under the owner's liability for failure to notify of an accident.
So made.
Court will grant that. How do you wish to plead? Either no contest or guilty? Doesn't matter. I'm okay with either. No contest. Court will enter a no contest on your behalf here today. I will assess $767.50. You have $1,000 cash bond posted. That will go towards this ticket. The remaining will be sent to the person, the individual who posted it, to the address that they provided. Okay?
Yep.
All right. Do you have any questions? Good luck. I'm sorry. Good luck.
Thank you.
All right. Thank you. We are adjourned.
Next, we have People versus Jane Lipinski. Okay, and that is file 4469 of 2024. Let's see, is that your case, Mr. Brott? Okay, Mr. Brott is here on behalf of the people, and this is the date for sentencing on the defendant's conviction of high BAC. You are representing yourself, is that correct, ma'am?
Correct.
Okay. And have you had an opportunity to review the pre-sentence investigation report?
Yes.
Okay. Did you find any mistakes with the report?
No.
Okay. And we're also here on a motion to show cause. And Ms. Jacobs, can you remind me what the show cause was? Is that the missed test on 12-4?
She's still there, Judge.
Oh, she's gone.
She might
Okay.
be meeting with
All
someone.
right. I think that's about some missed tests on November 5th. No, December 4th, I'm sorry. And December 17th and January 10th. Were you aware of those misses?
Just one.
Just
I
one.
only missed one that I know
Okay, well, according to our records, you've missed 3. Okay,
of. No,
So-
I haven't.
all right. Well, I'll let you explain anything else you want me to know about that. So anyhow, is there anything else you want me to know before I sentence you?
No. Guilty. I am guilty. And
Okay,
that's what I plead.
and are you agreeable to the conditions of probation that have been set out?
Yes.
Okay, actually, I guess there were no conditions of probation. They're recommending a straight jail sentence in this
Yes,
case.
I'll go to jail.
You would
Absolutely.
prefer to go to jail than be on probation?
No, I prefer probation. But whatever you give me is what I'll do.
You'll live with that, okay.
Yes.
Well, the reason that they're recommending no probation is because you failed to show up for the pre-sentence investigation report. and you didn't take some of these tests. And Ms. Jacobs, frankly, she's concerned that you're not going to follow through with the probation, and this is not going to end
Okay, I'll
well.
go to jail then. I will go to jail.
She's right about that then.
Huh?
She's right about that then.
I didn't miss 3. I missed 1.
Okay. All right. Anything else you want to say before I sentence you?
No,
Okay, Mr. Brott, anything for the people?
No, Your Honor, I think well, she missed the pre-sentence interview, she missed her substance abuse assessment. And so I think it sort of leaves probation with not a lot to go on other than.
Okay, thank you. So this is sentencing on the defendant's conviction of operating with a high BAC. The defendant pled guilty to the original charge. And the facts are that the sheriff's office was responding to a drunken disorderly complaint. And it was actually the defendant's sister who had also called to advise the defendant got in her car and had driven away from the scene. When the deputies found the defendant, she was intoxicated, very obviously so. She could hardly stand up during the interaction with officers and had to hold herself up against her car for support when she exited. The defendant, as with today, said, just take me to jail rather than do the field sobriety tests. So to her credit, the defendant has been very honest throughout this situation about taking responsibility for her actions. The defendant had a blood alcohol level of a 0.17, so that's why the high BAC. And she was ordered to take twice daily preliminary breath tests with an at-home machine. The defendant claims she missed 1 test, and nevertheless, I show that there were 3 separate violations. We don't receive a report from the Scram folks unless there's a violation, and that's why I pointed those out to you. Also, the defendant failed to show up for her pre-sentence investigation interview and did not complete the interview with Catholic Human Services. And so I have to agree with Ms. Jacobs. I think that this is probably going to not be a real successful probation. I don't think the defendant is a good candidate for probation. So then the question becomes, what is an appropriate jail sentence? The defendant does have prior convictions. There's a stalking in 2020. It says 1 year of probation. There was a DUI, again, a high BAC, 20 or greater, out of Florida in 2001. Now that's quite a while ago, but there's a pattern here because there was also another conviction way back in for DUI way back in 1976 out of Kalkaska. But anyhow, there is this pattern of drinking, and believe it or not, the prosecutor, I believe, could have charged a drunk driving third offense because you can go back as far in time as you want. That would be a 5-year felony. And I think it was appropriate to charge the high BAC and not go with the felony. But you should keep that in mind, that another prosecutor might not be so generous in that regard, okay?
yes.
So, and there's an assault in 1999. I'm going to guess all of these had something to do with alcohol, given the pattern of drunk driving cases. So, anyhow, it has been quite a while since her last drunk driving offense, but but then there was no accident in this case. No one was injured. Obviously, that was a strong possibility. The fact that there will be no rehabilitative services concerns me because I think you could benefit from substance counseling. But because we're not going to go down that road, I'm going to sentence you to 90 days in jail. That's half the maximum that I could impose. There is credit for 2 days that you've already served, and that is the sentence. I am also going to impose the minimal fines and costs. It'll be $100 fine, $100 cost, 75 crime victim, 50 judicial system fee. And if there's nothing else, we're all set. You'll need to go with this officer here, ma'am.
All right, we're on the record in Vander Kirchhoff versus Rapley. This is file number 2419803. The record should reflect that Ms. Rapley is connected by Zoom video. Oh, okay, Mr. Vander Kirchhoff is connecting as well.
Cool.
All right, Mr. Vander Kirchhoff, are you able to hear me okay?
Yes, I am.
Okay, so we have both parties connected now. This is set for a status conference today. The last time we met was back in November. The court referred the parties to community mediation and then set this for a hearing today. Mr. Vander Kirchhoff, as a plaintiff in this case, were you able to reach any agreements through the mediation process?
Just an agreement upon the Honda, and that was it.
Okay, are there other matters that are still need to be decided?
We have another vehicle that I was okay with just giving up, but she would like me to pay half of the debt on that vehicle.
Okay. Is there any other issues that remain besides the vehicle?
Not that I'm aware of, no.
Okay. Ms. Rapley, what's your view on that?
That we got married, and as a married couple, we decided to take on this vehicle and the payments and help each other out, and then he had an affair and left. So it's like, you're leaving me with the bill now? Really?
All right. How much is left owing on the vehicle?
Like 20 grand.
Okay. When was it purchased?
It was purchased of May, the end of May, beginning of June
Of what year?
this year, Your Honor.
Okay.
And
All
then
right.
he had like a month later, or a couple months later, and
All right. Do you have any idea how much that vehicle is worth?
yeah, it's worth like $25,000. That's how much the loan is for it.
Okay. Well, what the loan is and what the vehicle's worth might not be the same thing. So I'm just wondering if you know how much it's actually worth if you were to try and sell it, what you could sell it for.
Well, it's a 2021 Volkswagen. So I don't.
Okay. All right.
I don't know
So
how much the loan is for it.
okay. All right. So your position is that that you should sell it and that you should each be responsible for half the debt. What do you want to see happen with that car?
You know, I don't want to see anything happen with that car. I'll pay it. I'll be the woman here because I am. So, Your Honor, I'll pay it. Never mind. Forget it. He can have the Honda that's scheduled for 2 days from now at Secretary of State. We're all set. Just want to
Okay.
be divorced.
All right, are there any other matters, Ms. Rapley, any other items of property that need to be divided between the two of you?
No, Your Honor.
Okay. All right, so the court will set this for a final hearing to finalize the divorce. Mr. Vanderkerchov, there's a document that you're going to have to submit to the court prior to that hearing. It's called the judgment of divorce. That's a form. You can find that form in the same places where you got the forms to file for divorce. So you'll need to fill out that form and submit that to the court prior to the final hearing. And then the court will finalize the divorce on that date. The court will send you both a notice of the date and time for that hearing. That'll be by video, just like we're doing here today. Mr. Vanderkerchov, do you have any questions about what you need to do?
Nope.
Okay.
Thank you, Your Honor.
Mr. Rapley, do you have any questions at all?
No, Your Honor.
Okay.
Just want to be slam the hammer and divorce us. Finally.
Okay.
Please.
All right. Okay, well, we'll make that happen at the next hearing. Both parties are free to disconnect at this time. Thank you.
Awesome. Thanks.
Morning. So we are here for the small claims pretrial, cause number 24S000240. We do have the plaintiff here, Scott Jacobs, and the defendant, we have Jeff Bench here. Mr. Bench, are you just appearing on behalf of your wife as well, or is she with you?
She is with me.
Okay, perfect. And Linda Bench is also present with Jeff Bench. So in this situation, we do have proof of service. This is just a purely procedural hearing. We are going to go forward, just make sure that we have service filed, proof of service, and then we'll go ahead and set trial dates with going forward. So let me just check this really quickly. So let's see, Scott Jacob. So let me just look at the claim form really quickly. So Mr. Jacobs, it looks like you are requesting reimbursement in regards to a loan. And
Yes, ma'am.
you are requesting $635 to be reimbursed to you. Is that correct?
Yes, ma'am. I probably should have added the court costs and what it's cost me to bring them to court, but I didn't.
All right. And that would be going forward. Once we set trial dates, that could be included into the claim as well, just filing fees and just any.
Right. What it's cost me to loan them the money.
And I'm sorry. So what it's cost you to loan you the money, is that an interest rate that you're asking for? Or are you just saying that you want 600?
No, it's just what it's cost me to get the money back that I loaned them. Just the court costs, whatever I paid at the post office, you know.
All right. So just filing fees, all the fees associated.
Just filing fees and yeah, just what it's cost me to try and get back what I loaned them.
All right, sir. Okay, that makes sense. So, Mr. Bench, then you are aware then that that's what's being requested, $635 plus filing fees, which is pretty standard. Do you agree with this amount?
Yes, I agree.
Okay, so based on that information, do you just want to enter a judgment for that amount for you to repay Mr. Jacobs, or do you want to go ahead and proceed to trial in regards to this amount?
Yes, I'd like to go ahead and take care of this as soon as possible.
Okay, and I just want to clarify.
I'd like to pay him back.
Okay, all right, sir. So
thank you.
Okay, because sometimes it's better to just get that judgment in than go through the whole process of trial, especially if the amount is something that is in agreement. But maybe in this situation, Mr. Jacobs, I will enter a judgment then on your behalf for $635. The only issue is, since I am entering a judgment, I do need those filing fees right now. Would you be able to?
I'm in the courthouse right now, ma'am.
Okay, I don't need physical proof. Could you read them to me at this point? So that way Mr.
okay.
Bench could be aware of what the
Well,
amounts are.
okay. Let me see here. I'm horrible with paperwork, but
That's fine. If you
I
need a
believe I have
second,
a.
sir, if you
I
need a
think it was
second.
$35
Okay,
to file with
$35.
the court.
Okay, $35 filing
Let's
fee.
just add that. I think it was. I can't remember at the post office, but yeah, just the court filing costs would be fine. It was $35 to bring them to trial or do whatever it is we're doing here.
All right. Then 1 second, let me see. Retrial. Okay, so this is documents. Okay.
So $670.
Yes, sir. So it'd be $635 plus the 35 filing fee. It would be $670, and I will walk you
Okay.
through. I'll walk you through the paperwork right now. So
Okay, I would appreciate it because
yeah,
I'm not very good at it.
and everyone will receive documents in regards to this final judgment. And I want to tell you, Mr. Bench, that when this judgment arrives or when you receive it, if there are any payment plans that need to be set up, that needs to be set up directly with Mr. Jacobs, okay?
Okay.
All right. Did you hear that, sir, too? Mr.
Yes,
Jacobs?
that's fine.
Okay. If any payment plan needs to be set up, that doesn't go through the court. The court just gives you a judgment saying this is the amount that you're due, but any payment plans, that's between the both of you, okay?
Okay, then what you're saying is if the payments wasn't made on time or something, I'd have to come back in.
Yeah, unfortunately,
To
that's the situation. Yes.
Okay. Well, I don't think we'll have a problem there. I hope not, because we're neighbors and
Okay.
we need to just get back to being neighbors.
And I appreciate that. A lot of times that's overlooked and just to be
No,
amicable and
yeah, I agree. It's just money. People shouldn't fight over money. I mean, we have too many real things to worry about.
thank you. Thank you for being adults and respectful of just
Exactly, right?
Yes,
I mean,
absolutely. So let me get this written out. So this is okay. So I'm going to go ahead and grant a judgment to you. Your principal fee is $635. That's what you're asking for the loan. Then you're going to be getting $35 back for the filing fee. And then you're going to be this judgment is going to have a 9% interest rate on it. So
okay.
that means that if there is any issues with non-payment, a 9% interest fee would go ahead and be tacked onto this.
Okay.
So $670 is what I am going to be awarding you in total judgment.
Thank you.
All right, so
Thank you, Jeff, for not fighting it or anything. I mean,
you're welcome, Scott. Yeah, it's between you two. I appreciate both of you for just handling it, the right way. It doesn't need to be a battle. So good for both of you.
yeah, well, thank you.
Okay. Okay. All right. Okay, so once again, $670, 9% interest fee. So that is going to be sent out to both of you at the addresses on record. And then you said your neighbors, if you guys want to set up any payment plan for that $670, please work it out between the both of you. And if anything should arise going forward.
We're next door neighbors, so.
Perfect. And I mean this in the nicest way possible. I hope we don't see you again.
Well, thank you. You've been very nice, and I appreciate you guys' help. I'm old and slow, and so thank you very much. God bless.
I appreciate it too. I'll be more than happy to pay him off,
Perfect. That's all we can ask for. Just, resolve this, go back to being neighbors.
Okay, thank you so much.
That's what I really want.
Perfect.
That's what I really want.
Thank you so much. Appreciate it.
So we're all good?
You guys are all good.
We
Your
all
information
good.
will arrive in the mail and then $670. You guys are all taken care of. Everything's done.
Okay,
Judgment's
thank you.
entered.
You have a wonderful day. Thank you.
As well.
Thank you. You have a nice day.
All right.
Bye-bye.
Bye.
All right. So let's go ahead. If we could bring, I'm sorry, who did you say was here for United Finance?